Hi everyone, welcome to today's Board Basics webinar, Whistleblower Policies and Nonprofit Transparency. My name is Jason Q. I'm a managing attorney at the DC Bar Pro Bono Center in our nonprofit and small business legal assistance programs. So before we start, just a few housekeeping notes. There is on your GoToWebinar control panel a series of drop-down menus. One of those options should be called Handouts. On that menu, you should be able to drop it down and download a PDF version of the slides for today's presentation. Also on that GoToWebinar platform, we have a questions option. If you drop that menu down, you can type questions to me during the presentation. Depending on how much time we have or if we have time during the presentation, I'll try to answer your questions. If I don't get to your questions during the presentation, follow up with me online. My email address is going to be on the last slide, and you can ask those questions to me and we'll communicate via email. Okay, sounds good. So just before we begin, a little bit about the DC Bar Pro Bono Center. Our nonprofit and small business legal assistance programs matches nonprofit organizations with pro bono legal counsel here in the DC region. These pro bono attorneys can help with many different types of legal matters, so including corporate governance, IRS compliance issues, employment law, IP, real estate, anything under the sun. We also host in-person legal clinics to address specific legal issues like governance policies, insurance review, intellectual property. We sponsor trainings like today's event in the form of webinars and podcasts and live trainings on real-world issues facing nonprofits. And we also provide written resources and archive training sessions on our website. That website is www.probono.center/nonprofits. Today's webinar is part of our Board Basics webinar series. I've listed some of the other webinars in that series here. We have stuff on taking meeting minutes, meeting procedures, managing conflicts of interest, meeting an executive session, board committees. So all the sort of nuts and bolts of running your nonprofit board. We're trying to get some really user-focused, practical webinars out there to help you do that. So please share those resources with folks within your organizations and anyone else who you think might be interested. Okay, and finally, an outline of today's webinar. So we're going to start with some kind of high-level concepts and rationales for why nonprofit accountability and transparency is an important issue for nonprofits and a really important issue for the board. And then we're going to divide up into two sections. One I'm calling inside out accountability and transparency, and that's really going to be focused on whistleblower policies. How do we foster a culture of accountability, transparency, information sharing, and compliance within our organizations? And that can include kind of from within facing out into outside stakeholders. So that's about whistleblowers. And then the second section I'm calling kind of outside in, and that can be about public inspection of documents and other ways that we can disclose information about the nonprofit to the wider world. And that facilitates transparency, that allows third-party stakeholders and the government to oversee what we're doing. So that's another modality or another kind of dimension of accountability and transparency. One note that I want to make up front is that there are some special rules when it comes to the inspection rights of members in a legally incorporated membership organization. We're not going to be touching on those issues right now. As a really quick primer, your nonprofit can be incorporated as a membership organization, and legally that means that there is a class of individuals called members who have governance roles and functions and rights with respect to the nonprofit. Most notably, your members are going to be the individuals who elect the board of directors, and members also have annual membership meetings, and they're entitled to vote on important changes affecting the nonprofit. So if you are that kind of organization, if you're a legally incorporated membership organization, there are record-keeping requirements and membership inspection requirements that apply, and we're not going to touch on those today. Membership organizations are a minority of nonprofits, especially newer nonprofits. A lot of folks on the webinar might have folks that they call members who are invested in and participate with their nonprofit. That doesn't necessarily mean that you are a membership organization. You should check your articles and bylaws to see where you fall on that line. Okay, so let's start with our big first section. Why is nonprofit accountability and transparency important? For nonprofits, it can often feel like increasing your accountability and transparency can come with costs. It can definitely increase administrative burdens. It can potentially introduce new risks, and it does create new obligations, especially on the board, to follow up on potential misconduct or wrongdoing that you end up discovering. But there are a ton of compelling reasons why nonprofit boards should nevertheless foster a culture of accountability and transparency within their organizations and to adopt any related policies and procedures. And we're going to run through a number of them today. So the first big reason, and for the folks on this webinar as part of our Board Basics series, it's relevant to you, is that accountability and transparency supports the fiduciary duties of the board. So nonprofit directors have affirmative, legally recognized duties vis-a-vis their service to the organization as board members. These duties stem from statutory law. So here in DC, we have the DC Nonprofit Code that spells out some of your duties as a director, and also common law. So court-developed law that's been developed over time, kind of fleshing out and defining what duties nonprofit directors have. A number of these duties call on the board to foster a culture of accountability and transparency and to adopt related policies and procedures. I'll run through some of them. The first big duty is your duty of care. I like to think of this as the quality control duty. So nonprofit directors have to be competent and have to serve their nonprofits with a certain level of diligence. And a big part of that is acting on an informed basis. So a robust culture of information exchange and whistleblowing and accountability will help you as a director to just discharge that duty of care. A second relevant duty is your duty of loyalty. This is a duty that's really focused on conflicts of interest and making sure the decisions that you make are for the benefit of the nonprofit and not for your personal interests or others' interests. So having mechanisms for whistleblowing and transparency can help the board identify and root out conflict of interest transactions or other board-approved transactions which might not be in the best interest of the organization. And it's always better to identify and root out those issues early before they blow up or snowball into more serious issues. And we have a separate webinar on conflict of interest transactions in our Board Basics series if you're interested in learning more about that process. The third really relevant duty is a duty of obedience. So nonprofit directors are responsible for ensuring that the nonprofit and that their personnel abide by relevant laws at the federal, state, and local level, and that you avoid violations of your own organization policies and governance documents. So obviously having whistleblowing and transparency helps you discharge that duty. And then finally, some states, including DC, have a separate duty to inform, which is a duty on both directors and officers to report violations of the law or policy or other forms of wrongdoing. So your whistleblower policy provides a roadmap for how that reporting is going to happen. And again, it empowers folks in the organization to actually make those reports. I'm going to check periodically to see if there are questions or comments. So, okay, we're good. A second big reason that you want to make sure that you take accountability and transparency seriously is that there are some legal requirements that apply. So for example, at the federal level, we have the Sarbanes-Oxley Act. This generally applies to for-profit organizations, but there are whistleblower protection and anti-retaliation provisions that apply to nonprofits as well in the relevant contexts. So when we get to whistleblower policies, we'll talk about how they should have anti-retaliation provisions in there to support compliance with this act. In the context of government contracts or use of government funds, the False Claims Act also protects whistleblowers who bring to light information about the misuse of government funds. In DC, we have the Whistleblower Protection Act. So for nonprofits that contract with the DC government, there are anti-retaliation protections again for individuals who bring misconduct to light or other information. And as we'll discuss later, the IRS also has rules requiring the public availability of certain organizational documents. So what we're going to be talking about today on the webinar helps to ensure compliance with all these legal requirements. Speaking of the IRS, I mean, the IRS is definitely the biggest government player in this sphere. The IRS asks organizations if they have adopted a written whistleblower policy in Part 4 of the annual Form 990 information return. If you go to the Form 990 instructions, the IRS explains that a whistleblower policy encourages staff and volunteers to come forward with credible information on legal practices or violations of policy, specifies that the organization will protect individuals from retaliation, and identifies those staff or board members or outside parties to whom information can be reported. Here's what it looks like on the actual 990 itself. It's in section B of part 4 and question 13. Did the organization have a written whistleblower policy? You check yes or no. Like a lot of these governance policies that show up in the 990, it's not a requirement legally under the Internal Revenue Code, and checking no on the box doesn't come with any immediate or direct consequences. However, the IRS uses these governance questions to assess the overall robustness of your nonprofit's governance systems, and that assessment may in turn inform your audit risk, especially if there are too many red flags. So, taken as a whole, as part of a bigger picture about your governance structure, the lack of a whistleblower policy can be one red flag or one factor that informs the IRS's thinking about your organization's governance systems. So as the IRS explains, even though the information isn't required, it considers policies and procedures to generally improve tax compliance. The absence of appropriate policies and procedures can lead to prohibited acts or illegal acts, or acts in violation of your nonprofit status. Okay. Similarly, when we come to kind of the issue of public disclosure and transparency, there's another section on the IRS that asks whether and how you make certain corporate records and documents available to the public. So we'll talk about that as well. Now, this is all on the full Form 990. Some folks, if you're smaller, you fill out a different form of the 990, maybe the 990N or EZ. Those forms don't have these specific governance questions, but you should still be looking to the fact that the IRS is interested in this issue as a roadmap for where you want to take your organization. And when you do grow and kind of pass the threshold where you have to file a 990, you don't want to be caught in a lurch and have to adopt all these policies in the last minute. So I definitely encourage all nonprofits to use the 990 as a roadmap for governance. And so you can't be kind of too small to have a whistleblower policy or other related policies. Okay, so moving on, another big rationale for why we want to take accountability and transparency seriously is because it helps with risk management. Implementing the culture of accountability and transparency creates an environment that discourages, on the front end, employee theft, fraud, embezzlement. It discourages prohibited transactions between the nonprofit and its officers, directors, and key employees. And it discourages other misconduct involving the nonprofit's resources and personnel. By adopting these policies, you signal to the world and to folks within your organization that you're serious about preventing and investigating wrongdoing. You can also think of accountability and transparency as a kind of internal control against loss when misconduct or wrongdoing does occur, because by detecting these events early, it gives the organization an opportunity to prevent the situation from continuing or escalating or becoming worse, and you can prevent added liability that could stem from your nonprofit's failure to act. And finally, insurance providers may consider the existence of whistleblower policies and other governance policies and procedures when assessing your organization's governance systems, and then by extension, when judging your organization's risk profile. A fifth rationale that we want to touch on is this issue of having internal versus external investigations. And what I mean is that fostering accountability and transparency will spur nonprofits to develop the capacity and the credibility they need to handle complaints and to conduct investigations internally. So if you don't have a whistleblower policy and if you don't have robust transparency, whistleblowers or just concerned third parties outside of the nonprofit are more likely to report their suspicions or their concerns externally as their first resort. So they might immediately go to the Attorney General that regulates nonprofits. They might go to other government agencies. They might go to the IRS. They might go to the media, etc. So kind of a practical benefit of taking this seriously within your organization is that at least in the beginning, you get to control the investigation process, and you can do it in the relative privacy of your organization. One example or one kind of data point from Chronicle of Philanthropy, this is from an Attorney General. At the end of the article, he notes, an organization that tries to follow the best practices of transparency can prevent government investigations. When I've received a nasty complaint about a Missouri charity, I've decided that the allegation might be true, but upon doing a preliminary review online, I found that the nonprofits in question were so transparent that I could verify that the complainers had it wrong, all without leaving my desk. Those nonprofits have no clue how close they came to large and embarrassing investigations. So right from the source, right from a government regulator, we can see how transparency can prevent external investigations, or it can prevent the kind of expansion of an external investigation. And finally, the last kind of big rationale is that accountability and transparency is really important for engaging your outside stakeholders. So for donors and government entities, for prospective employees and board members, and for the general public, everyone values transparency and accountability when deciding which nonprofits to support. Coming out of Candid, formerly GuideStar, last year was some research that showed that nonprofits that kind of upped their transparency metrics on GuideStar received 53% more contributions in the following year, and were stronger organizations across a range of governance, financial, and operational dimensions. So there's one data point for how this can have a real effect on your nonprofit's bottom line and its reputation in the community. Speaking of GuideStar and Candid, third-party nonprofit watchdog and rating organizations are basically in the business of accountability and transparency, so they take this stuff really seriously. For example, for Charity Navigator, accountability and transparency is one of the two key dimensions that inform their nonprofit ratings, along with the financial health. And their accountability and transparency performance metrics include your governance practices. It includes the existence of whistleblower policies, and they look at the extent to which information records are available on your organization's website. So this all feeds into, there's literally points for each of these factors, and it all feeds into your organization's overall rating. Going back to GuideStar and Candid, they have a program that awards seals of transparency in, I think it's 4 levels, from bronze to platinum, according to how much information your nonprofit makes available to the public. So aside from all the legal stuff, there are kind of good stakeholder engagement, kind of public relations reasons for why you want to take accountability and transparency seriously. Okay, so let's get into kind of our first meaty issue, which is this issue of whistleblower policies and procedures. And whistleblowing is always in the news when it comes to nonprofits. Some recent stories, an Oxfam whistleblower came out in 2018 saying that they failed to act on sex abuse allegations. And right now we're still reeling from the Me Too era. So allegations of sexual harassment and abuse in institutions, whether for-profit or nonprofit, always on people's minds. And it's always something that can be triggered or discovered through a whistleblower process. And that's often for the best long-term. Another big story that came out in 2018 about the Silicon Valley Community Foundation. There's kind of a big story about the toxic culture that one of the leaders of that organization created. And that whole story was triggered and put together through whistleblower complaints to the journalist who wrote the article. So some examples of when whistleblowing has been a significant factor. We've touched on the IRS's perspective, but a little bit more commentary from the Form 990 commentary. The IRS believes that a well-governed charity is more likely to obey tax laws, safeguard assets, and serve charitable interests. It encourages your board of directors to adopt an effective policy for handling complaints and to establish procedures for employees to report. That being said, if we look at the actual numbers, and this is from February of this year, from the Nonprofit Times, a majority of nonprofits don't have a whistleblower policy. So if you're sitting there and your nonprofit doesn't have one, you're in the majority at the moment. According to the Nonprofit Times and a run of the numbers that they performed, only 41% of nonprofits they looked at, drawing on 990 data, had a whistleblower policy. So we as a sector have some progress that we still need to make. Okay, let's get into the anatomy of a whistleblower policy. And at the end of the presentation, I'll have a link where you can go to a legal alert that we have on this issue that includes our template whistleblower policies. So if you need somewhere to start, you'll have that resource. But a lot of policies, and our policy starts with a purpose statement, kind of setting the tone at the top. It generally connects the whistleblower policy to the organization's broader commitment to transparency and accountability, to ethical conduct, and to legal compliance. Here's the language that we have. I'm not going to read it, but it's setting the tone, it's setting the purpose up front. Next up, a whistleblower policy should establish an affirmative responsibility to report wrongdoing. So to reinforce this culture of accountability, we want to make it a responsibility of staff, officers, directors, and volunteers, and that's important. We should be including volunteers in these policies as well, to come forward with credible information on illegal practices, on violations of organization policies, or other unethical conduct. Let's cast a wide net. The policy should encourage reports even if it's only based on suspected violations. It should establish that there will be no penalty for submitting a good faith report, even if no violation ultimately has occurred. Again, it's about creating that culture, that open door policy, you'll hear some people say, for whistleblowing and for complaints. However, to maintain the integrity of your whistleblower program and to prevent abuse or harassment, the policy should explicitly prohibit reports made maliciously or in bad faith, or otherwise when the reporter should have known or does know that the report is false. We do want some consequences for filing a negative report. In our template policy, we say that filing, not a negative report, I'm sorry, a bad faith or malicious report. In our template policy, we spell out that that's a disciplinary violation for folks who file a malicious or bad faith report. Another section that you'll see in a lot of whistleblower policies is having a compliance manager. So we want to make someone accountable and responsible for overseeing the whistleblower complaint and investigation process. So that should be a designated compliance manager that's implementing the policy and that's investigating the claims. And who this person is really depends on how your organization is structured. So it could be the CEO, your COO, your CFO. If you have these titles, it can be your HR person or department, or someone with HR capacity for smaller organizations. If you have in-house counsel, that's a really good job for in-house counsel. You can designate a board member. You can make it the chair of your audit committee. A lot of times audit committees are also internal investigation committees, or you can use a designated third party like an outside law firm. Your compliance manager can also be a designated report receiver. We'll get to that, but they shouldn't be the only option. Okay, we've touched on this quite a bit. Your whistleblower policy should definitely have an anti-retaliation section. The policy should explicitly protect whistleblower reporters if they're acting in good faith from harassment, retaliation, or any other adverse employment consequences. The protections should also extend to individuals who cooperate in a whistleblower investigation, and the policy should establish a parallel reporting process for actual or suspected instances of whistleblower retaliation. So the policy shouldn't only create a process for filing the report in the first place, it should also create a mechanism for filing complaints or information related to retaliation against whistleblowers. Okay, and then let's get to sort of the meat and potatoes of it. What are the reporting procedures under the policy? So the policy should first and foremost identify staff, board members, and outside parties to whom reports can be made. And the ideal is to have multiple reporting options. We don't, for multiple reasons, reporters might feel more comfortable talking to one person or another, or sometimes a person might be implicated in the wrongdoing that's the subject of the report. So we want to make sure that there are multiple options for reporters to go to. In our template policy, we identify the compliance manager, certain designated board members, and then also any other manager as an appropriate report receiver. You can designate outside parties to be report receivers, so that can be an independent accountant or an independent attorney. These folks are much less likely to be implicated in the substance of the report itself, so they can be a much safer option for reporters, more objective or neutral option. And the organization can also create an anonymous reporting process on top of your in-person reporters. It can be a hotline or a web form that can solicit anonymous reports. Going on, to satisfy your duty to inform, you got to make sure that your officers and supervisors are required to escalate their reports up. Under our template policy, at the end of the day, all the reports ultimately flow to the compliance manager, because the compliance manager, again, is responsible for ultimately investigating those reports. Confidentiality should be valued and anonymity protected as the report is escalated and investigated, but don't guarantee confidentiality in your policy. Only assure it to the extent possible to facilitate an investigation Sometimes total confidentiality will prevent us from effectively investigating the report. And then finally, when it comes to investigations, again, the compliance manager is responsible for conducting the investigation with the support of the board and the executive director as needed. In our template policy, for issues that involve finance-related complaints or financial mismanagement, we can designate the CFO and/or the audit committee, if we have those individuals or committees, to be the investigative body for those sorts of complaints, since they have the subject matter expertise and the technical ability to investigate those complaints. Okay, so that's the high level kind of sketch of what our whistleblower policy looks like. Again, we have a template policy that I'll link to you on the last slide. Some general tips for implementing your whistleblower policy. First of all, make sure that the policy is widely distributed to your board, your staff, and your volunteers. You should also incorporate it into orientation programs, into your handbooks, and into your other training programs for folks inside the organization. Specifically, you'll want to train your report receivers on their duty to take reports seriously, to protect confidentiality, and to escalate reports. A big risk with whistleblower policies is it's almost worse to have one but not properly implement it or abide by it than to not have it at all. It can create new kinds of liability for the organization. So if you go back to our template approach, where we make any manager a designated report receiver, the flip side of that is that we have to make sure all of those individuals are trained on how to properly accept and escalate those reports. Ensure that there's ongoing board oversight regarding the policy and its implementation. If your compliance manager is not on a member of the board in particular, you have to go the extra step of scheduling regular check-in meetings with that compliance manager. Even if they are a member of the board, you still should be intentional about receiving regular reports from that individual on what reports you received and how the policy is being implemented. And then this is another tone at the top kind of issue. You have to enlist the board and senior management to talk about the importance of the policy and your commitment to the policy to create that culture of accountability. We know that if staff and volunteers don't hear leaders in the organization taking it seriously, they're gonna think potentially that this is just kind of window dressing and that they're not actually expected to use this procedure. Okay. Something I want to touch on is how your whistleblower policy can intersect with other reporting policies and requirements. So for example, this is the big one. If you have an anti-discrimination or anti-harassment policy, which you should, and it should include sexual harassment because that's a big issue in our world, those policies often have their own reporting procedures. Make sure that they're aligned with the reporting procedure in your whistleblower policy. Sometimes, or a lot of the time, a complaint of discrimination or harassment is also a whistleblower complaint. So try to align those policies as much as possible. Failing to align those reporting policies and procedures can create confusion and inhibit reporting. People, if there are kind of two very different reporting structures, people might not know what to do. One caveat or one sort of distinction that is pretty common is that your anti-discrimination and harassment policies will often have HR be the first point of contact. And again, I recognize that small nonprofits don't usually have freestanding HR, but a lot of times we see HR as being designated the first point of contact for those kinds of violations because they're usually personnel violations, and that makes sense. Whereas many organizations will have whistleblower complaints elevated to the board or the chief executive or to a third party, whoever that compliance manager is, that might not necessarily be HR. So it does make sense if you want to have HR be the primary point of contact for your discrimination and harassment policies, but you just have to make that distinction clear for the folks within your organization. Another area that this touches on is equal employment opportunity. So under Title VII, the anti-harassment discrimination policies there also require a reporting mechanism. So having your whistleblower policy creates that mechanism if you don't have one already. As above, ensure that your EEO reporting procedures are aligned with the whistleblower procedures. They can be exactly the same if you want. For folks who are mandatory reporters, because you work with vulnerable populations, you work with children, ensure that triggers for mandatory reporting are cross-referenced in your whistleblower policy. We don't want someone looking to the whistleblower policy and missing the fact that there are mandatory reporting requirements at play as well. And then also for folks who work with vulnerable populations, that's an especially important area where we want to make sure that you have whistleblower policies. If you're working with children, the elderly, if there are parental or caretaker notification procedures, build that into your whistleblower policy because those might be triggered. Sometimes folks have freestanding child safety policies, for example, which have their own reporting requirements. Again, in that policy, as we've been saying, make sure that those are aligned with your whistleblower policy. And it's hard to give kind of general advice in this area because everyone's policy is different, every organization is structured differently. When I say aligned, at minimum, you don't want conflicting advice about where to go. So you don't want your whistleblower policies to say you must go to A, B, and C, and then have another policy say you have to go to D, because again, some people won't be able to figure out, is this complaint involving a vulnerable person also a whistleblower complaint? And in reality, a lot of the times they're both. So want to make sure that those policies work together. Okay, so that's it for whistleblower policies. I'm checking for questions. Okay, let's see here. Can you recommend any software or platforms, etc., for anonymous reporting? That's a good question. I don't know if there's sort of a best practice in this area. Folks can just set up anonymous Microsoft forms or Doodle forms. Nothing, because those don't require people to put in an email address or anything like that. That's a curious question. I think if we're worried about, well, we're definitely worried about data security. So make sure that there are real limits on who can access that information on the back end. Even though the reports are anonymous, we don't want the reports to be kind of broadly accessible to everyone in the organization. We want to make sure that there's some controls there for who can see what's being reported. Okay, so public inspection of documents and information disclosure. This is the second dimension, maybe the other side of the coin when we talk about accountability and transparency, whereas whistleblower policies are about making sure that information and complaints flow out from within the organization, up through the organization. This is about allowing people outside of the organization to peer in and to make sure that there is no misconduct and to make sure that our policies and procedures are in good shape. There are some strict legal requirements in this area. So for the IRS, under the Internal Revenue Code, a nonprofit organization must provide or make available for public inspection a copy of your last 3 Form 990s. So it could be your 990, your EZ, or your PF, whichever is applicable, including schedules and attachments. For 990Ns, for very small organizations, those are filed online and are made available on the IRS's website. There's no sort of physical form, so people can get information about those off the IRS's website. But if you file a 990 or an EZ, you have to make those available to people who want to inspect those. So it's a 3-year period starting from the due date of each 990, including any date extensions, and then rolling for 3 years after that. If you file the 990T for tax on unrelated business income, this is the UBIT filing, you have to make those available as well, including any schedules, attachments, or supporting documents that are relevant to calculating your UBIT amount. You can and should redact the names and addresses of donors or contributors listed in your 990, including on Schedule B. So when you make these documents publicly available, they should be the original documents. They should be identical to your original documents. The one exception here is that you can redact donor information, identifying information. You also must make available for public inspection your application for exemption that you submitted to the IRS. So that's your Form 1023, your 1023 EZ, along with all attachments. And finally, you should have your IRS determination letter available for people to inspect as well. So what do we mean by making publicly available? It's surprisingly kind of dense, but at the high level, your nonprofit should always be prepared to provide these IRS required documents to individuals upon request. And that can mean on site. So the public, members of the public, are able to just show up at your door, and you must be able to produce on the same day for those requesters your 990s or your 1023. If if they show up at an office with administrative staff and it's 3 or more employees. For those who lack of that kind of fixed or permanent office, you have some extra time to produce the documents for these people. People are also allowed to send you requests by mail. So if they write or fax or email a request, you're supposed to respond within 30 days. If you're mailing copies out, you can charge actual postage costs. You can mail them back, say it's going to be, $4, and then, they can send that to you if you do that if you let them know within 7 days. Okay, so aside from actually making the documents available for inspection, you're also responsible for providing requesters with copies that they can kind of take home. And there are 2 big ways to do this. You can make them available online. If you make them available online, you don't actually have to give people physical copies. You can give them a link or information about where to download the stuff online. So you can post these documents on your organization's own website or allow the documents to be available on another entity's website. This would be Guards That Are Candid, Foundation Center. The IRS is building out its own 990 database. So as long as there's somewhere online that you can link people to, that satisfies the copies requirement. Under either option, virtual documents must be identical to the original. They should be in PDF. And again, you have to provide requesters with instructions on how to find them. If you don't post these documents online, then you have to be ready to provide copies, physical copies to take home upon request. So either on site, you literally print them off, at your office and give them to people as they walk in, or if it's a mail request, you mail out the physical copies to those people. You can charge requesters reasonable copying costs. They're pegged to what FOIA records currently cost, and actual postage fees. Some other kind of high-level tips. When it comes to penalties, the IRS can actually level penalties of $20 per day for failure to comply with these public inspection rules, up to a max of $10,000 for your 990s, and actually no max for the 1023. If a nonprofit can't find a 990 or your 1023, there's a form 4506A that you can file with the IRS to request those records. If your nonprofit feels like people are submitting document requests as part of a coordinated harassment complaint to kind of disrupt or tie up your administrative staff, and that has happened, it does happen, the IRS has a process that will allow you to apply for basically an exemption with respect to those requests, so you can stop complying. Likewise, if you're getting multiple requests from the same person or address, it's like 2 requests within a month or 4 within a year, you can start to ignore some of those subsequent requests. There's a process for that as well. So the big takeaway for folks, because I know you're board members, you're probably not staffing the mailroom, but you should ensure that your nonprofit has procedures in place for dealing with document requests. Even if your documents are available online, staff should be trained on how to handle mail or on-site inspection requests. I think a lot of on-the-ground staff don't understand that if someone walks in off the street and says, hey, can I have a copy of your 990, you actually have to say, yes, we'll get that for you. A lot of folks will say, no, like we don't have to do that, or go online or whatever. But if it's that kind of in-person request, you have to be ready to produce those documents. Another issue that I see here is folks do tend to have their 990s available somewhere on the internet, but that might not be true for the 1023. So people should understand that you have to have a procedure that allows people to get copies of your 1023. If your 1023 isn't on your website or another website, people should be prepared to kind of print it out and mail it out or hand it out upon request. Let me see if there are questions in this area. Okay, great. So those are the legally required documents available for public inspection. You might have peeked and seen that on the 4990, the IRS also asks if your nonprofit makes its governing documents, so those are your articles and bylaws, your conflict of interest policy, and financial statements available to the public. It's a pretty open-ended question, I'll show you. So that's question 19 under section C, part 4. Describe in section O whether, and if so, how your organization makes those documents available to the public during the tax year. This is sort of like that question about the whistleblower policy. These are not legally required, but they do demonstrate a kind of enhanced commitment to transparency. So for those who want to be in really good shape, it's sort of a nudge, nudge, wink, wink from the IRS that maybe there should be some way of making these documents available to the public. But that doesn't mean that you have to post them on your website and make them really widely available. You can have a process where you provide these documents upon request. And then when you write this narrative to the IRS, you can just say, we provide them to whoever they asks, we send it via email, et cetera, and just explain that that's what you do. Third-party watchdog and nonprofit rating organizations, so again, these are the guide stars and charity navigators of the world, also tend to look for a lot of information on a nonprofit's website when assessing overall transparency. So again, these are not legal requirements at all, but kind of from a practical or best practice standpoint, you might want to think about putting this additional information somewhere on the internet. So again, there's always this demand for financial information. The best thing you could do is put your audited financial statements up on the internet. Actually, California has, for example, a law that requires this kind of financial disclosure. Audited financial statements are reviewed externally, so there's a lower chance that your nonprofit will provide the public with what ends up being inaccurate financial information. It does give me some heartburn, the idea of putting unaudited financial statements on the internet, there being some sort of inaccuracy or problem with those statements, people relying on that information, and then that blowing up the nonprofit's face. So if you have audited financial statements, that's preferable. I know a lot of folks don't undergo audit, they're too small. If you don't, but you still want to post your financial statements, at least have them reviewed by a CPA. There's a kind of lower, less onerous process for reviewing your financial information that's available. A lot of watchdogs and rating organizations and members of the public want to see bios of your board members and key staff. You might want to post other organization or governance policies. So again, the IRS hinted that maybe your conflict of interest policy should be available somewhere. Charity Navigator is really interested in whether you have a donor privacy policy, and they want to see that on your website. You might want to put your whistleblower policy up there if you really want to hammer home that you take whistleblowing seriously, or if you have a large corpus of volunteers or people who work with the organization that are actually covered under the policy, but that you don't, send out employee handbooks to. Having the whistleblower policy available on your website is one way to make sure that those folks know about the policy and actually can use it. Putting your annual report on your website is a good practice for transparency. And then there's other kinds of detailed programmatic information like quantitative metrics, descriptions of your strategy or your theory of change, progress reports, etc. For GuideStar/Candid, for their Seals of Transparency program, to get that platinum rating, you actually have to provide these kind of quantitative and qualitative metrics and information about how your nonprofit is accomplishing its mission. So that's sort of a spectrum we can think of information to also think about putting on your website. But again, that's not a legal requirement here. Let me do another question check. Okay, let's see here. There are some, oh, okay, wait, I think I see a question. Okay, so I missed this question from earlier maybe, but the question is, under what circumstances should the board go straight to the police or other law enforcement authority rather than trying to investigate the allegation themselves? I'm thinking of embezzlement, significant theft, etc. These can be parallel processes. You can trigger your internal investigation process, and also if there's just been a large theft from the organization, you probably do want to let law enforcement know right away, but you can have those steps running parallel. Or you can just immediately escalate that issue to the compliance manager, and it should be the compliance manager's call to then kind of immediately call the police or get other third parties in to come and investigate. But no, the instinct is totally right when it comes to significant theft or embezzlement. You don't want to sit on that and not report that to the relevant authorities. Doesn't mean that it has to override or be an alternative to your whistleblower process internally. Actually a note about that is also another body that you definitely want to inform is your insurance carrier. So if you find yourself the victim of theft, embezzlement, etc., let your insurance broker know right away, let your insurance provider know subsequently that has occurred, because there are notice requirements under your insurance policies as well that you don't want to forget about. So just because you're investigating it internally through a whistleblower process, that doesn't mean you can skip notifying your insurers. You want to do that right away. Another question, going back to whistleblower policies regarding the compliance manager's reporting, is there best practice? Should the compliance manager report each quarter, even if there are no reports, report at each board meeting or at other intervals? So in our template policy, we recommend quarterly reports, even if there have been no complaints received. I think that's just to keep the board engaged in the whistleblower process and to like remind them that the compliance manager exists and that they're doing something. If you do receive a report in the interim and there's a board meeting coming up, I think the board would want to know about that event. So you might want to also have a mechanism in there for kind of ad hoc, by per occurrence reports to the board as well. But yeah, our default is a quarterly check-in no matter what. Okay, so there are some documents that I sometimes see available for public inspection, but that there might be some problems with. So let's think this through. The first big one is meeting minutes. So some folks post their meeting minutes on their website. It's not a good idea. Meeting minutes should be a place where directors can discuss issues candidly and openly, including potentially sensitive or confidential or controversial matters. Kind of having the possibility of public disclosure inhibits robust meetings and really keeps the board from performing its fiduciary duty of care. So keep your board minutes private unless disclosure is required by some sort of sunshine law. That's not something we see often in DC. If people really want, if you want to be super transparent or give your members or stakeholders information, I've seen some folks do like a really high level summary of their board meeting that's more abstract and kind of curated than the meeting minutes. That's okay, but don't go posting your actual minutes on your website or elsewhere online. That leads me to a little aside that we always do about meeting minutes, which is that the trend is, more often than not, nonprofit meeting minutes are way too detailed than they need to be. So I'm giving that caveat, that tip right now. Your minutes don't need to be a transcript of what was said during the meeting. They're meant to be a record of what the board did during the meeting. So instead of saying Sally said X, Y, Z, and then Jim said X, Y, Z, you can say the board discussed blank issue and just tell people that you discussed it. That's your function. It doesn't matter exactly what the specific points are. It's that you went through a deliberate process, you had open debate, and that at the end of the day, you made a vote or you made a decision. So your minutes should be tracking kind of how the board is performing its key functions. It shouldn't be a detailed transcript of what people are saying. That's my little aside there. Confidential or protected information. So definitely want to safeguard confidential and sensitive information, like any kind of information regarding personnel. So make sure you're not publicly disclosing any of that stuff. Even worse, to disclose protected information like HIPAA protected health information, credit related information, stuff like that. Be super careful around that information. You should definitely be respecting your donor privacy. So we touched on how you should be redacting donor information out of your 990s. Make sure it's not leaking into other documents or onto your website. Budgets. Budgets are meant to be flexible and dynamic and a tool of the organization internally. They don't provide useful real-time information to third parties really, because your actual spending is going to be changing all the time. And you have other ways of providing financial information to the outside world, like through your financial statements or your financial reports. So keep the budgets kind of within the organization. You don't want people trying to hold you accountable to a budget because they don't understand kind of the function of that document versus your financial statements at the end of the day. And in a similar kind of vein, your strategic planning documents, these are, again, they're designed for internal use. They can and often should critically discuss sensitive or controversial matters affecting the organization. It's how your organization is thinking through problems affecting the organization. To serve that function to be useful, we want a certain amount of privacy and kind of openness internally with those documents. So probably shouldn't be making those available online, although I do see it on occasion. Let's see here. Someone said they lost the volume. So I don't know if that's still an issue. I'll check and make sure that that's not an issue all the way across. Apologies if the volume dropped out. There's a question, can you give an example of when bylaws should be made public? I think you can have your organizations, you can have those organizational documents available upon request. If it's You can ask an outside requester why they're asking for the information. You know, that can be part of your process. If it's sort of, for example, like here's an example that I've seen. It's a member of the public or one of your volunteers who's interested in becoming a board member, and sort of the instructions for how elections work and how board members are elected, those are in your bylaws. So, you know, that's a good reason to give someone your bylaws. There shouldn't be anything really spicy or problematic in your bylaws that you're trying to hide from the public. So I wouldn't be too worried about disclosing those on demand or even making those available online. If you're really confident in your bylaws, if you think that they do a really good job of involving the public, your committee structures are on point, you're kind of proud of the work that you've done, I mean, you can even think of that as an externally facing kind of document that you're happy to share with the public. So, okay, great. Okay, and then there are a couple other times when you have to disclose information to the public via your 990. So this isn't about making entire documents publicly available. It's about checking certain boxes of the 990 and letting the public know that certain events have happened. The big one here is a material diversion of assets. So on every 990, the IRS asks you if you became aware during the year of a significant diversion of your organization's assets. If yes, you have to describe the circumstances, how much money was taken, what corrective actions you've taken, etc. in Schedule O. So a diversion of assets is any unauthorized conversion or use of your organization's assets other than for the organization's authorized purposes. So that's including but not limited to embezzlement and theft or theft by any person. So for both people inside the organization, but also outside the organization. It's a material diversion, and so it has to be the lesser of one of these three options: 5% of your gross receipts, 5% of your total assets, or $250,000. So if that occurs, you got to check the box and then sort of describe to the IRS, who will then make available to the public what happened. Another category is related party loans. So in multiple sections of the 990, the IRS will ask for detailed information about loans you've made to current and former officers, directors, trustees, key employees, the creator or founder, substantial contributors, or 35% controlled entities of those individuals, or family members of those individuals. These are disqualified persons, we think of them as in IRS lingo. It's a wide net. The big takeaway here is that related party loans are a financial and governance red flag. They are not common in the nonprofit sector. They're not encouraged. They are at high risk for conflict of interest or private inurement problems. They very often do not advance the mission of the nonprofit. And then here in DC and in many other states, nonprofits are prohibited under our nonprofit code from loaning money to officers and directors. So if you're making related party loans, those have to be disclosed in the 990. You can't sort of sweep those under the rug. So I wanted to let folks know about that. And with that said, that's it. So here are some resources. That whistleblower policy, probono.center/whistleblower. Look at that legal alert, and at the end of the legal alert is the policy. Our general website for nonprofit resources is probono.center/nonprofits. And then our board service section, which includes all of our board basics webinars and will include a recording of this webinar, is probono.center/nonprofits. We have a bit more time, so if people have other questions they want to trickle in. Do you recommend that the bylaws prohibit related party loans? Yeah, that's a good provision to have in the bylaws. It tracks the statutory law, which is an important function of your bylaws, is to kind of ensure compliance with the DC nonprofit code. So you can say in there, no loans to officers and directors or employees if you want. Although employee loans are not prohibited under DC law, the same way that officer and director loans are prohibited. Okay, great. Well, thank you everyone for logging on or for listening to this webinar. My email address is there, jqu@dcbar.org. If you have any questions about this topic or just any other question related to nonprofit governance or operations that have a legal angle. Great talking to everyone. Enjoy the rest of your day.